Good morning, you all. Today I want to look at the CCMA process. I've had a lot of inquiries about this, and it makes sense because people are not well accustomed with the process and they normally script themselves do it if they come to the CCMA. So firstly, let's look at the referral of a dispute. In terms of the Labour Relations Act and the rules of the CCMA, the dispute must be referred to on a Form 711. For unfair dismissal case, it must be within 30 days of the dismissal, and for unfair labour practice, it must be within 90 days of the act or the awareness thereof. If you are late, you need to apply for condonation, which you must please Google, and it needs to have an explanation and the prospects of your success in it. Okay, then secondly, process starts in terms of Section 135 of the Labour Relations Act, always with conciliation. The CCMA schedules it within 30 days of receiving the referral, and the Commissioner acts as a mediator. He's not a judge, he just acts as a mediator. Lawyers are normally not allowed, except in certain discrimination cases or if the Commissioner allows it. And then if they reach a settlement, it's written down and can be made an order of court. If no settlement is reached, the Commissioner will just write down matter unresolved, and then we will go to the next steps. The next step after conciliation, and here's where the confusion sometimes comes in, because everybody just accepts that after conciliation arbitration comes, and that is not the case. It depends on the type of dispute. Unfair dismissal for conduct or capacity goes to arbitration at the CCMA. Automatically unfair dismissal, discrimination, strikes, large-scale retrenchments, etc. must go to the Labour Court. And this is often where people get confused, because not every dispute goes from conciliation to arbitration back to the CCMA. But if it does, in terms of Section 136 to 138 of the Labour Relations Act, the employee can request arbitration on a Form 713 within 90 days of the certificate of outcome of, listen, we couldn't agree on anything. If you remember what I told you a bit earlier, that the commissioner will issue, and then it will lead to a formal hearing. So there will be witnesses, cross-examination, lawyers, etc., the whole shebang. I think that most of your dread will be happening there, but do not be afraid, because legal representation is allowed. The Commissioner then listens to the story and he acts as a judge. It's not a mediation anymore. He acts as a judge and he makes a decision, and it will be issued, the award will be issued within 40 days, the answer. It's binding and it will be enforced as if it's a Labour Court order. Important to know that after this process, you can send it for review back to the Labour Court. You can apply to the Labour Court for review. It's important to know that this is not for, it's not based on the merits of the case. You can it's not an appeal. It's a review only of the Commissioner's conduct and reasonableness of the decision. Also a bit tricky. Just listen, just hear what I say. You don't have to understand it at this point. And then just a few common myths that I want to correct. The CCMA is free legal representation. Ania Abuta, it is not. In Allah, no, it is not. The process is free, but you must arrange your own lawyer or union support. So it's the same as a lot of other legal stuff. It costs you money, unfortunately. If you go to arbitration, I will definitely think you must rather bring your representation with. You can file anytime. No. Also no. The time limits apply and condonation is not agreed. So it's important. The one thing I want you to remember from today is the timelines I gave you in which you must bring your application, and secondly that after conciliation, the mediation, playing nicely with the mickeys there. If no agreement is reached, you're basically going to a trial set up at arbitration, or you're going straight to the Labour Court, and it's not a month's a month. So, but not to scare you, but that's the process.